I also thought we'd start with a very colorful picture, which should be appealing to Canadians. I hope I didn't forget any of the flags of the provinces, but I counted, so there's 13, so I think I'm okay. So we're gonna talk about. I'm gonna talk specifically about data residency, but this presentation, the next one, and the one after are all related basically to a common topic of data governance or information governance, if you prefer. And we're in the midst at OMG of wrapping the various topics within the general subject of data governance into a coordinated initiative. So we formed a new working group at our last meeting, or 2 meetings ago, I don't know, and we had actually a meeting of what we now call the Data Governance Working Group, rather than having a separate Data Residency Working Group. So we met on Sunday afternoon to progress our work. So that's what I'm going to describe a little bit. And I hope I use the right button here. Yes. So what is data residency and why does it matter? We had to come up with a definition actually at OMG. It turns out that when we looked at the issue, which was raised by a member of OMG to us, and that's how we kicked off the work on this topic, we looked for a common definition, and we found that there was not a general definition that had been adopted and that was authoritative. So we had to look and make our own. It hasn't been challenged since then. It seems to work. So residency is a set of issues and challenges, as well as the ways to mitigate those challenges, etc. That is the best practices in this area related to the location of data. So it's not the location per se. If you say my data is in Vancouver, well, that's not necessarily a data residency issue. It is if the fact that it's in Vancouver creates some problems versus the laws of another province, for instance. So the issue is, where do you put the data and the metadata? Where is the data in transit or at rest? And therefore, what my colleague Stephen Woodward calls the geo-jurisdictions, which is a term that's been used by ISO, protecting the data against unintended access or other location-related risk. It matters because it goes beyond issues of privacy and security. So data residency is not just about the protection of personal data, and it affects all sorts of types of information. It creates a number of risks, and it is hard to parse the legislative texts that have a bearing on where you can store your data. And the impact, if you violate unwittingly law or regulation, can be dire, and there's not enough standards about this. So all sorts of data can be subject to issues of residency. Obviously, personally identifiable information, PII, tends to be the thing that you think about first, and then it means that the issue of residency overlaps with the issue of privacy, and obviously patient health information has sort of the same status as PII. But then you have proprietary corporate information, you have all sorts of, everything related to collaboration, like emails and presentations and calendar entries, etc. Obviously, government information, military information, anything that is considered sovereign data, information subject to trade controls, so where you store technical information, if you're a company that makes complex systems, may be relevant because you may have government rules against making some of that technical information accessible from some countries. So if your information by law or by government rule cannot be exposed to people from North Korea. You want to know if North Koreans would have access to the information if you stored it in a certain location, or maybe if you have a cloud provider that can load balance between servers in Canada and servers in India or in China, would the Chinese copy of the technical information be accessible to North Koreans and therefore create a problem against some sort of embargo law? So the issue becomes very complex. And you have countries where information on natural resources is also protected. I don't know what is the situation in Canada with respect to oil and gas information, but I can tell you that in Russia and in Venezuela, and Venezuela may not matter that much right now given the chaos there, but Russia certainly does matter. It is illegal to take any information about the subsurface of Russia and take it outside of the country. Etc. So these are my slides about trying to scare you. You know, after that, I'm going to go a little bit into what are some of the potential solutions or directions. But the first few slides usually are the horror story, you know, of data residency. And as a result, if you get paralyzed by that, and if you're trying to totally avoid exposure by not putting data elsewhere, that tends to go totally counter to all the cost savings and the technology evolutions that we've seen recently, including the ability to use cloud services where you do not necessarily control where the data is going to be stored. And for the cloud providers themselves or the managed hosting providers, it means being impeded in their business development by potentially not being able to satisfy the need for trust of their customers that the data is going to stay under control. It may prevent a multinational company from consolidating operations. For instance, if employee personal information, you know, social security numbers, date of birth, etc., if that needs to stay in the country where the employee resides, it means that a multinational company would not be able to have a single consolidated human resources information system. And obviously, that's not what companies do today. If you take a company that is multinational, they usually have a central ERP system, a central HRIS system, a central CRM system, etc. Therefore, they're going to have some personal information of people from country A being stored in country B. And if you were not able to do that, then all sorts of efficiencies and business processes would be impeded. And then, of course, you don't want to be in conflict with authorities. You don't want to have your image tarnished in the press for having had a data leak due to the fact that the data was in a country where it was less protected, etc. And at the end of the list, there's the societal impacts that can happen if IT businesses and the owners of data, as well as the custodians of data, are losing the public's trust that they are responsible stewards of information. So an example one is migrating to the cloud. What if I want to migrate stuff that was on premises and put it in the cloud, but my cloud providers are somewhere else, or they are liable to load balance their servers between multiple countries? So even if there's just the possibility that they might move my data to another country, I can't even see my pointer, it's so small, that's a risk. The regulations may be unclear, and then you have a perverse effect, which is that a number of CIOs and IT managers are using this argument to say, we're not going to go to the cloud. And they're not necessarily doing that because they're worried about your personal information. They're doing that because they're trying to protect their jobs and not lose their data center, which is the pride of their career. And they don't want to they want to resist the orders from on high to move to the cloud by saying, oh, you know, if we move to the cloud, we're not going to know where the data is stored, so I'm not going to do it, which, you know, rejects a perfectly rational policy of going to the cloud. I've been given the example by clients in Mexico who said, no, we cannot do that because the data might be outside of the country. I said, show me the law that says that you cannot store the data outside of the country. They were unable to show it to me. So it was clear that, I mean, their concern might have been justified, but their claim that they rejected the cloud because it was forbidden due to a governmental law was actually a fake one. Okay, but there have been counterexamples. There was a Danish bank that several years ago obtained authorization from their government to store their data in a UK-based cloud. Maybe that will change next March after Brexit, I don't know. Genomic data sets, we discovered during the early days of the working group I was chairing that the exchange of genomic information between research institutes and hospitals around the world is very fragile with respect to data residency because of the risk that the sample data that is being used might not be anonymized sufficiently to mask the identity of the subjects who provided the DNA information, or could be re-identified again because anonymization is not always foolproof. We have this example of petroleum reserves, and in particular the example of Russia. But that I mentioned, if a geologist from Calgary goes to visit colleagues at a conference in Moscow or in Siberia and puts some data on his laptop in order to run his own algorithm for oil reserve calculation and forgets to delete that data before getting on the plane to come back, he is violating Russian laws. And could, in theory, be if his laptop was inspected at the border and found to contain this particular model of an oil reservoir, he could potentially be fined or arrested and tried for spying, for espionage. Things like that, okay. And I've seen examples of countries that were unable to consolidate IT resources because government of one country said, you cannot take my data and put it, or our data, and send it to a data center in another country. We even had an interesting example I ran into where, which was in Brazil, where Petrobras, the oil company, said, yeah, sure, you can take your data to Houston, process it, and return it to us, but the government requires payment of value-added tax on the increased value, on the value added to the data by processing it. Well, how do you value how many dollars is that processing worth? Guess who decides on the value of the data exported and the value re-imported? The Treasury Department, so they're judge and party. They can arbitrarily say, you exported data worth X and re-imported and it's worth 2X, and you're going to have to pay 60% VAT or 60% customs duty on the value of that data. Fourth example is the famous, at least in my world, it's a famous example of Microsoft versus the Federal Bureau of Investigation in the United States, where a citizen, an American citizen, was suspected of being a drug dealer. The FBI wanted to seize the person's communications. The person was using Office 365 from Microsoft on the Irish server of Microsoft because they had claimed that they were a European citizen when they opened their Office 365 account. That claim was probably false, but anyway, that's where their data was. And Microsoft said to the FBI, we cannot give you the data, it's on a server in Ireland. And the case was actually in the courts for 4 or 5 years, reached all the way to the US Supreme Court, and just before it had to be adjudicated by the US Supreme Court, the American Congress passed a law and said, oh, by the way, it was called the Cloud Act, and it was an amendment to a previous law, and it said, oh no, the US has the right to obtain data from anywhere in the world about things like that. So Microsoft then decided to comply, but of course that doesn't mean that the Irish or the EU are very happy about that. So there's the question of which law prevails. There's a proliferation of laws around the world. This is just a few. You can perhaps read the name of the countries from the back of the room. You can see the slides. I have all the details, if not on the slide, because I tiled all this together, so you cannot read all the details. If someone is interested, let me know, and I will send you the details I have. This is actually courtesy of IBM. But these are some of the examples of the regulations that exist. And red means it's very stringent and in place. Yellow means it's a proposed regulation. There's not that many green ones, even if you unmask the masked slides. So there's a bunch of countries in the world, and this is just a subset, that have rules about financial data that cannot leave the country, natural resource data, PII, PHI, patient health information, etc. You also have regulations and trade pacts. Boeing has done quite a study on this that they shared with us. And of course, now we have the EU GDPR, which is in force since 25th May. So we did a study at OMG. We created a request for information. We issued it. We got responses from a bunch of people. We compiled the responses. And the problem we found, the main problem, at least the thing that scares me the most, is the fact that when you say, who's in charge of governing or managing data residency in your company, the answers are scarily imprecise or inoperative. And the first 4 bullets here are actually exact quotes from the responses I got. And when people tell me there is a cross-functional data residency working group under in the legal department, or even more vaguely, various roles including policy, security, technical, legal, information modeling, or a collaboration of engineering, compliance, and legal, etc. Basically, when there are multiple people in charge of something, you know that if an accident happens, you're going to get what we ironically call the circular firing squad, where everybody is going to fire at each other. You know, you call it finger pointing too, but the image of a circular firing squad is telling. And if everyone is in charge, no one is in charge. And we all know from responsibility assignment matrices, you know, the RACI principles, responsible, accountable, consulted, and informed, that you can have multiple people responsible for various things, but you need to have only one person or one role accountable. Otherwise, things won't happen. And it is very clear that the current state of the art, if you want, in commercial and government organizations, I think, also is that there is vagueness and uncertainty, and therefore insufficient management of the issue. So sometimes it's at the business line level. Sometimes it's at the CEO level. Well, frankly, the CEO probably doesn't understand 10% of the issue, and it's not going to be the CEO's, the top of mind issue for the CEO on a daily basis. So if you push it up to the top, I think that's an easy solution, but it's probably not very effective. Sometimes it's the CIO, the CTO, or the legal office, and that may be fine. Sometimes it's the CIO and the chief security officer together, etc. So there's a lot of immaturity in how data residency is being managed. And generally, governance is not very good. So when we issued a discussion paper, a 30-page paper that was published in May 2017, so a year and a half ago, basically, we actually, in the discussion paper, were pretty normative, we were pretty firm on 5 steps that needed to be taken in order to correctly handle data residency issues, establishing governance structure, making sure we manage metadata, defining the processes, doing monitoring and reporting, and if possible, implement tools to track where the information is. So we've discussed all that. And then we issued in December, I think it was probably only announced in January, but it was adopted in December of last year, so December 17, less than a year ago, a Data Residency Maturity Model, DRMM, which is here. And you don't have to read everything, but basically, and especially since it's cut off a little bit at the bottom, but you can still read it. So it's inspired by the Software Engineering Institute Capability Maturity Model, the original one from 1990 or 1991 that defined the maturity of software engineering. So we took the same 5-level definition, initial, repeatable, defined, managed, and optimizing, with the fact that it's a gerund, that it's optimizing, not optimized, being very important semantically, because it means when you're at the optimizing level, it never ends. You're in a continuous improvement process, so it's important that a lot of people make the mistake because it says define, manage, they say optimized. You're never completely optimized. You can only be optimizing. So it helps to know your parts of speech and to have learned a little bit of sentence parsing in school, because you can say, I believe in gerunds. So there's a definition for each of the 5 levels, and there's a set of key process areas which are the things you need to do in order to be able to say you're at that level. So, you know, it starts with awareness and informal practices, but then it goes on to having formally documented process, a taxonomy of your data that may be sensitive, training, etc. And then it keeps going up. And in order to be optimizing, you have to have some sort of continuous process of monitoring, detecting deviations, auditing your data location. So for instance, if you have a cloud provider, you may need to have the contract with the service provider telling you where they're storing the data, what form of notification they're going to give you if they intend to move the data somewhere else. And you may need to have some monitoring tool that allows you to interrogate the cloud provider's servers and say, where is this piece of data now? Please report back to me on which instance of which machine is currently holding such data, so that I can verify that it is in Vancouver, not in Shanghai. Things like that, okay? So we proposed this at the end of last year. We really want feedback on it, more feedback than we have gotten, and we're trying to propose it to some other organizations like NIST in the US, National Institutes for Standards, for NIST, whatever, it's NIST. T is technology, S maybe standards, I don't remember what they call themselves. OMG is just as bad as the government with acronyms, so we know the pain. Anyway, we were looking at that. Maybe NIST could make it into a special publication, and then that would help us at OMG get more visibility. So there is a white paper that is 30 pages long, and there's a 9-page paper that contains, as a single page, this model. And all of these documents are available from the OMG. They are public. You can actually probably Google them and find them by just Googling them. The program contains actually information on the page where my presentation is listed. You can actually get some of that information in there. So follow that URL, get those papers, send us feedback. We'd love to see this being more published, more used. So we started 3.5 years ago. As I said, we formed a working group. We issued an RFI. We partnered with the Cloud Standards Customer Council, which no longer exists. It's become the Cloud Working Group of the Object Management Group, and I also co-chair it, so it's a little bit incestuous, but at least it means the two efforts are well coordinated. I'm not that schizophrenic. We published a discussion paper, we published the maturity model, we've been given a whole series of tutorials and webinars. Some of those webinars, or most of them, are recorded and available for replay. If you need more information, let us know. And then the data residency effort is part of the new data governance working group. We have a bunch of people who participated in our work. But we have a lot of organizations who said, well, we could tell you what we're doing or what we're not doing about data residency, but we don't want other people to know what we're not doing because they might jump on the opportunity to trash us in the press. So there was an issue of retention of information. So summary, we think it's a serious challenge. We think that mostly people need to learn about it and understand where the risks are for their respective organizations. And then people need to mobilize themselves in terms of establishing governance of what they do with their data with respect to the geographies where it resides, where it can be transferred to or through, who is using it from where. If you have a remote help desk in India, and those people get to see the information on the screen because for the purpose of the help desk, they're observing a user's screen. Does that mean that you're effectively exporting to India the one database record that's being displayed on the screen when the help desk agent is observing you? People don't think about that sometimes. So again, learn about it and then develop business and technical approaches to mitigate the risk. We're looking into what standards may help. So we're thinking of issuing an RFP to create a standard for the formalization of data laws and regulations because they're all written in various languages. In the US, people say they're all written in English. Here, I would say they're all written in English and French. But these are equally ambiguous languages. So can we formalize what the obligations are in order to be able to reason about them? Take a piece of data and its description, take a regulation and its formal description, mash them together and say, red flag, you cannot do that, or you cannot put it outside of your country, etc. And therefore, in order to participate in this, learn what we're doing, you can participate in the, actually it's no longer data residency working group, it's data governance working group now, and participation is if it's just to the working group, is free as long as you ask us for an invitation to come to a meeting. And we will have some conference call meetings, so they're not all face-to-face meetings. Take our work and use it as you please. It's there, it's out there for you to use. And even though I said the Data Residency Working Group has become part of the Data Governance Working Group, we still have a URL, omg.org/data-residency, so there's still a page that gives you access to the document we have. So there's 3 minutes left for questions specifically on data residency, but the next presentations are also about other aspects of data governance. Questions?
Any questions?
In your discussions, do you talk about technology solutions to this problem? I'm thinking about things like encryption, anonymization, or even, the provider's tendency these days to create cloud repositories in different governments to serve residency issues and challenges.
Yes, we do. Not necessarily to the extent you might like to see, but we talk about encryption. We talk about the issue that sometimes when you encrypt your data, some governments tell you that you need to escrow the keys with the government, which then sort of can defeat the purpose if what you're concerned with is accessed by a foreign government. So we do discuss that. We also discuss some other technologies, some of which come from OMG and some from others that could be used to add metadata about residency to the data. So things like XACML and other technologies. So yes, there is some discussion of it in the paper. probably something that would benefit from being augmented.
Anybody else?
I've heard a lot of things about this, the Patriot Act, and I guess you sort of touched on the fact that the U.S. is able to to access any data around the world. Is that something that that we need to be aware of? If all these companies that are becoming our cloud vendors, even though the data resides within Canada, is that something that needs to be considered, or is that a red flag?
Absolutely. So as you know, before GDPR existed, there was a thing called the, Europe, as you know, has been a leader in terms of, regulations for privacy, and that has come out in the form of the GDPR. But before that, in the fall of 2015, there was a problem because there had been a so-called EU-US privacy shield in place where the European commissioner had decided to allow US companies to self-certify as being compliant with the handling of data of EU citizens. And the EU Court of Justice adjudicated in October 2015 that allowance was not valid, and they killed it, which was a very important thing. And if you read the EUCJ decision, it's actually quite amazing. The judge the EU Court of Justice judge who wrote the decision explicitly said that in their consideration was the fact that the Patriot Act killed any credibility that the US companies could self-certify as protecting your data. So that's an anecdotal evidence, but it is an anecdotal evidence that your concern is absolutely well placed, and that and look at the Cloud Act that Congress in the US enacted last year, because that is a bit scary, because it says we have the right to get data anywhere in the world if it's data pertaining to someone that we're investigating. That's a very broad power.
Thank you, Claude.